everyone, and welcome to another edition of the BWF Solicitors Weekly Update. This afternoon, we've been discussing on the Community and the Law Show the case of Akinsanya. This Wednesday, the Court of Appeal finally handed down the decision in the case of Akinsanya regarding Zambrano carers and parents. Now, it was a positive decision, and we've been discussing how this is going to impact on primary carers, joint carers, and other carers of Zambrano children, i.e. children who are British citizens in the United Kingdom. Well, the decision itself agrees with the Home Office on the ground one, where the Court of Appeal agrees with the Home Office on their interpretation of the European Union law, which basically means that if you are here on a 2.5 years or some sort of a leave and you're required to leave the UK, your child would not be required to leave the UK if you're required to leave, because you have leave already, and so that does not affect you at all. However, if you're here without leave and you're asked to leave, then of course, indeed, technically, the Home Office would be asking for your child to leave as well, and the court does not agree with that. The other thing is the court does not agree with the position where the Home Office seeks to discriminate, if you like, against parents and carers of Zambrano children who have been somewhat been compelled to make an application under our domestic immigration rules and being granted 2.5 years and cannot reverse back to apply for indefinite leave to remain under the Appendix EU settlement scheme for settled status. With that, the Court of Appeal disagrees with the Home Office and have ruled that the Home Office should go back and then change the guidance to affect all of these people who have been granted 2.5 years and are on some sort of a leave leading to settlement here in the UK, in that if they have looked after a British citizen child for 5 years and more, then as the law is been clearly stated, they would be able to apply for indefinite leave to remain. And for that reason, the Home Office should basically change their guidance and their rules to make sure all of these people are captured in there, because it wouldn't be fair to allow those parents who are primary carers and sole carers to be able to make the application under the scheme for leave to remain, but then seek to discriminate against those who've been compelled, as I said earlier, to make an application under the domestic law, not to be able to apply for indefinite leave to remain. And this is what we've been discussing. We feel it's a very good news, and we've been waiting for this to come through, and finally it's here. What we're saying to the community is that take advantage. If you're already on a 2.5 years and you've been looking after a British citizen child for over 5 years, then you would qualify under the Zambrano principle for indefinite leave to remain under the Appendix EU settlement scheme. And so we're encouraging you to call your lawyers, call BWF Solicitors on 0208-493-7340, 0208-493-7340. Make an appointment and we can further discuss your case and tailor every single advice to your circumstance. We hope this is useful and helpful to all of you. Same time next week, we'll be back here discussing other topical issues on the community and the law. Thank you very much for listening.